Tribunals: Supreme Court, High Court, Metropolitan Level Civil, City Civil Court, and Courts of Small Causes Criminals, Sessions Court, Metropolitan and Magistrates Court, District Level Civil District Court, Civil Judge, Senior Division and Junior Division, Criminal Sessions Court, and Judicial Magistrate Tribunals, Central Administrative Tribunal, Income Tax Tribunal, Motor Accident Claims Tribunal, Cooperative Tribunals, Rent Control Tribunals, National Green Tribunal, Industrial Court and Labor Court, Family Court. High Courts. There shall be High Court for each state, Article 214, and every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Article 215. The writ jurisdiction of High Court means issuance of writs or orders for the enforcement of fundamental rights and also in cases of ordinary legal rights. High Court also has the power to superintend over all other courts and tribunals except those dealing with armed forces. High Court's power of original and appeal jurisdiction is also circumscribed by the creation of central administrative tribunals with respect to services under the Union, and it has no power to invalidate, declare void a central act, rule, notification, or order made by any administrative authority of the Union. Supreme Court. The Supreme Court has vast jurisdiction and its position is strengthened by the fact that it acts as a court of appeal, as a guardian of the Constitution, and as a reviewer of its own judgments. Article 141 declares that the law laid down by the Supreme Court shall be binding on all courts within the territory of India. Article 131 gives the Supreme Court exclusive and original jurisdiction in a dispute between the Union and a state, or between one state and another, or between a group of states and others. The Supreme Court is the highest court of appeal from all courts. Arbitration. It is a well known fact that the present judicial system is extremely expensive and delaying. The parties to a dispute have to wait for justice for years. This lengthy and expensive process of litigation has reduced the faith of common people in the judicial system being followed by the courts. These weaknesses of judicial system has given birth to alternative remedies for the disposition of disputes. Alternative remedies provide cheap and speedy justice, and that is the reason that ADR mechanism is being preferred by the disputing parties for the resolution of their disputes. ADR refers to the methods of resolving a dispute which are alternatives for litigation in courts. ADR processes are decision-making processes that do not involve litigation or violence. In India, an alternative system is available to the disputing parties, including arbitration, conciliation, mediation, negotiation, etc. ADR proceedings are flexible. The parties have the freedom to choose the applicable law. They can be conducted in any manner and in the language to which the parties agree. The matter may be settled in few meetings, thereby reducing expenses. No court fee is payable. No expenses are involved in obtaining copies of proceedings and reports. Arbitration is a method whereby parties can resolve their disputes privately. In this mechanism, parties can refer their case to an arbitral tribunal where arbitration proceedings are conducted, where two or more persons agree that a dispute